Valid trust. A valid trust is created when a settlor has the intent to give property, res, to the beneficiary in a bifurcated transfer. The settlor gives the residential to the trustee, who has legal title, to hold for the benefit of the beneficiary, who holds equitable title. The trust need not be in writing unless required to by the statute of frauds, for example transferring an interest in land. The beneficiary need be ascertained, but the trustee does not have to be. The trust can be revocable or irrevocable, and it is presumed irrevocable unless otherwise stated. Revocation/termination of trust. A trust can be revoked if the settlor is alive and has explicitly reserved the right to revoke the trust. Otherwise, it can only be terminated if the material purposes of the trust have been fulfilled. Appointing a trustee. A trust will fail if it does not have an ascertained beneficiary, or if it does not have any property currently in it, except for a pour-over trust. However, the trust will not fail if a trustee has not been named, or if a trustee either refuses to serve or needs to be removed by the beneficiaries or the court. The court will appoint a trustee, or the beneficiaries may vote on a trustee. Remainder interest. A remainder is a future interest that vests upon the termination of a life estate. It is vested if the beneficiary is ascertained and there are no conditions precedent. Valid will. A formal valid will is created when there is a writing that is signed by the testator and indicates present testamentary intent, intended this document to be her will, and is witnessed by two witnesses who sign the document as well. Pour-over trust. A trust can be created by the language of the will. Therefore, the property is held in trust upon the death of the testator, instead of being distributed through probate. Present possessory interest subject to an executory interest. A present possessory interest is when a person has a current interest in property. It is subject to an executory interest if it can be divested by a third party. Duty of loyalty. A trustee as a fiduciary has the duty of loyalty to the trust. He has the duty to act in a reasonable manner to ensure the best interests of the trust beneficiaries. He can violate this duty by self-dealing with the trust or by taking an action that would be adverse to the trust beneficiaries. Duty of care. A trustee also has the duty to act as a reasonable person would in caring for the trust. He has the duty to use any special skills he may have, and to treat the trust property as his own in his care for it. Duty to invest. At common law, a trustee was limited to a specified list of investments that he was approved to make. Now trustees are expected to diversify investments in order to spread the risk of loss, and the whole portfolio will be considered. Duty of impartiality. The trustee has the duty to fairly balance the trust assets so that the current beneficiaries and remainder beneficiaries are treated fairly. He still had the duty to be impartial when making his investments so that neither the income nor the principal drastically decreases. Duty to inform beneficiaries. The trustee also has the duty to keep beneficiaries reasonably informed about major decisions, including the trust property. Removal as trustee. A trustee who breaches his duties may be removed as a trustee. A trustee can also be removed for other reasons such as death or incapacity, or if a serious conflict exists with the beneficiary. Tracing. Finally, when there is self-dealing and assets are invested, the beneficiaries can seek to retrieve the funds through tracing. Will. A valid will must be in writing. It must be signed by the testator in the presence of two disinterested witnesses at the same time who also sign the will. Trust. In order for a trust to be valid, there must be a testator, a beneficiary, trustee, trust purpose, and trust property. Conservator. A court can appoint a guardian or conservator to act on behalf of a person who lacks the mental capacity to act on their behalf. They have the authority to make legal decisions, such as drafting a new will. However, a conservator still owes the testator a fiduciary duty of care and loyalty. The conservator must act in the best interest of the testator and not make any decisions that are self-serving and are directly adverse to T's interest. Lack of capacity. Generally, a person lacks capacity if they are unable to understand the nature of their estate, the nature of their relationship with family and friends, and the nature of their act of creating the will. Cypress. Under the Cypress Doctrine, the court can modify a charitable trust purpose if the trust purpose has been frustrated. Will substitute. Where an inter vivos trust is created, and where the settlor gives a vested future possessory interest in the trust to a grantee, it will be considered a will substitute. Pour over will. Where the settlor has included a clause whereby all of the settlor's assets at the time of his death pour into the trust for the benefit of the beneficiaries, a pour over will is created. The will requirements must be established to make this valid. Omitted child, unknown. In general, a child may be disinherited if the child is left out of a will or other testamentary document created by a parent. However, where a child is unknown to the parent at the time the testamentary document is created, and the parent had no reason to know of the child, that unknown child will not be disinherited, and will be able to recover his intestate share of the parent's estate. A child's intestate share in a modern per stirpe system, which is the majority view taken, will be an equal share split at the first level of inheritance, in this case among the children. Trust termination. The power of termination depends on whether or not a trust is revocable or irrevocable. An irrevocable trust is created where the intent of the settlor is to make it as such. Here S expressly stated that the trust is to last until the death of the last of the three named children. The majority view is to find in favor of irrevocable trust, so it is likely that this language will be sufficient to establish an irrevocable trust. Termination of irrevocable trust. Termination of an irrevocable trust can be done, either when the settlor and all of the beneficiaries agree while the settlor is still alive, or if all of the beneficiaries agree, and it will not frustrate the purpose of the trust, or a merger where the trustee has become the sole beneficiary. An irrevocable trust is created when the express language of the settlor states as such. Type of trust established. To a certain extent, a trustee's ability to use discretion varies depending on the type of trust that is established. The greatest deference is given to the trustee in two situations, either a support trust or a discretionary trust. Both of these types of trusts, generally, must expressly state that this is the type of trust being established. The purpose of the trust, which is a necessary requirement of a valid trust, should determine what type of trust is created. Fiduciary duties of trustee breached by T. A trustee has a number of duties to the beneficiaries of the trust. Among those duties are A. A duty of care, B. A duty to distribute benefits in accordance with the trust, C. A duty to treat beneficiaries equally, D. And a duty to follow the settlor's instructions. Only in certain circumstances is the trustee allowed to use discretion in how to distribute the income of the trust, namely a discretionary trust or a support trust. The trust duties to the beneficiary are triggered by a trustee accepting their position as such. Where a trustee has breached their fiduciary duties, they may be held personally liable, and or may be removed from their position by the court. Duty of care. A trustee has the duty to act as a reasonably prudent person in her dealings as trustee. This includes investing reasonably, making reasonable distribution, and all other activities that a trustee conducts in her role as trustee. Duty to distribute in accordance with the trust. A trustee has a duty to distribute in accordance with directions given in the trust instrument. This duty is breached when the trustee acts in a way inconsistent with the specific instructions set forth by the settlor. Duty to treat beneficiaries equal. A trustee should give the same care and deference to each beneficiary of the trust, in accordance with the trust purpose.